Hi everyone, and welcome back to the Flow Migration Law channel. I'm Jay, the principal lawyer here. Receiving that notification that your permanent partner visa, that's the subclass 801 or 100, has been granted. What a moment of pure relief and happiness. It truly marks the end of a long, demanding journey and the start of a secure future with your partner here in Australia. You're a permanent resident. But sometimes a question still lingers. Often it's fueled by stories you hear online or from friends. What can cause a permanent partner visa cancellation? What happens if your circumstances change down the track? Can the Department of Home Affairs actually take your visa away? The short answer is yes, it is possible, but, and this is a very important but, it only happens in specific and serious circumstances defined by law. The government cannot cancel a permanent visa on a whim. Before we dive into the details, a quick reminder. This video contains general information and is not legal advice. Every situation is unique and Australian migration law is complex. If you have concerns about your visa status, you should always consult with an Australian legal practitioner or registered migration agent. Alright, let's walk through the legal grounds for when a permanent visa can be at risk. And just as importantly, clear up common misconceptions that cause unnecessary worry. Holding a permanent visa provides a really high level of security. You're no longer on a temporary visa. Your right to live in Australia isn't tied to the day-to-day status of your relationship. However, a permanent visa is granted based on the information provided and the circumstances presented at the time of decision. It also comes with the ongoing expectation that you will abide by Australian laws. The Migration Act contains specific powers that allow the Minister for Home Affairs or a delegate to cancel any visa, including a permanent one, if certain conditions are met. These powers are not used lightly. For a permanent visa holder, the grounds for cancellation are generally limited to serious issues. So let's look at the primary legal reasons why a permanent partner visa could be considered for cancellation. Ground number 1, failing the character test. This is one of the most serious grounds. The character test is an ongoing requirement for all non-citizens. Your visa can be cancelled if you fail this test after it's been granted. The most common trigger is acquiring a substantial criminal record, which is defined in the Act and includes being sentenced to a term of imprisonment of 12 months or more. It can also include convictions for sexually based offences, including a child, or if you are reasonably suspected of being involved with criminal organisation or conduct that poses a risk to the Australian community. So, abiding by Australian laws is paramount. Ground number 2, providing incorrect information or bogus documents. This is all about the integrity of the information you gave the department in your application. Public interest criterion, PIC 4020, is aimed at preventing fraud. If it's discovered, even years later, that you provided a bogus document or false and misleading information in your visa application, your visa can be cancelled. Section 109 gives the department the power to cancel a visa if you provided incorrect information on your application or passenger card and you haven't corrected it. This could apply even if the incorrect information was a genuine mistake. Section 116 provides general cancellation powers, including where the decision to grant the visa was based on a fact or circumstance that did not exist or no longer exists. Ground number 3, fraudulent relationship. This is a crucial point. If the department receives information and subsequently finds that your relationship was never genuine and was entered into solely for the purpose of obtaining the visa, they can move to cancel it. The focus here is on discovering that the basis of the visa grant was in fact a sham from the beginning. So let's talk about what does not lead to cancellation. Now this is the part that should bring the most reassurance. For holders of a permanent partner visa, the following situations do not form grounds for visa cancellation. First, relationship breakdown after the permanent visa is granted. This is the most common fear, and we can be very clear here. If your relationship with your sponsoring partner ends after you have been granted your permanent partner visa, your visa status is safe. You're a permanent resident in your own right, and your status is no longer legally tied to that relationship. Number 2, sponsor withdrawal after the grant. Now, your former partner cannot withdraw their sponsorship or have your visa cancelled once it's permanent. The sponsorship undertaking is considered complete at the time the permanent visa is granted. Any attempt to do so afterwards will have no effect on your visa. The key distinction here is timing and honesty. The department's concern is whether the relationship was genuine up to the point of the permanent visa grant. What happens in your personal life after that milestone does not impact your residency. So how to protect your visa status being a permanent resident means upholding the law and the integrity of the system. The best protection is simple diligence and honesty. Abide by Australian laws. This is paramount. Avoid any criminal conduct is the single most effective way to protect yourself from character-related visa cancellation. Ensure your history is accurate. If you later realize you made a genuine error or omitted something on your original application, speak to an immigration lawyer. Proactively seeking legal advice is the sensible path forward. Keep personal details updated. While you're not required to notify the department of a post-grant breakup, you should always keep your relevant contact details updated in your EMI account. This ensures you receive any official correspondence. If you ever receive a Notice of Intention to Consider Cancellation, a NOICC, it is a very serious matter. But remember, it's not a final decision. It is your opportunity to respond and present compelling reasons why your visa should not be cancelled. Responding to a NOICC or any concerns about your visa status is something our team at Flow Migration Law handles regularly. With over 8 years of dedicated experience in Australian migration law, including challenging government decisions and dealing with complex visa problems, we can provide guidance to help you protect your future in Australia. If you're worried about something in your past application or you've received a formal notice from the department, we invite you to book a confidential consultation with us. We can help assess your situation and discuss your rights and options. Thank you for watching. If this video was helpful, please give it a like and subscribe for more Australian immigration insights. I'll see you in the next video.